doing as much as we can. You're truly right.
The following is a production of Temple University Beasley School of Law.
Thank you all very much for joining us for this year's Friel-Scanlan Award. I want to begin by acknowledging Francis Scanlan, who was a beloved member of our years, who endowed this award in honor of his aunt and uncle, Francis Friel and Sarah Scanlan Friel. And this is an award that goes annually to a faculty member chosen as having that year's most outstanding scholarship. So introducing the presenter of this speech each year is a great joy for me. It's an opportunity to celebrate one of the best things that we do here. This year's award recipient, Professor Jaya Ramji Nogales, has been with us since 2006. She has a resume that is unbelievably impressive, which of course I reviewed in anticipation of introducing her today, not something I do regularly. And I'd forgotten all of the many places that she has worked and whose lives she has touched. And so, Jay, I want to acknowledge publicly how very pleased we are to be associated with you. Since 1997, Professor Ramji Nogales has worked in a variety of capacities to assist victims of the Khmer Rouge in Cambodia. She is a national and international speaker and panelist. The number of law review articles is too numerous to list. Book chapters. She's also written 3 books. One of my favorite titles is an upcoming article of hers called The Right to Have Rights, which is a forthcoming symposium piece that I look forward to reading. I think I want to say, for those of you who don't know her, and I suspect that many of you in this room do know Professor Ramji Nogales, she achieves what many researchers and scholars hope to achieve, which is to write and have impact. And so I wanted to acknowledge the fact that her writing has been impactful, a word I don't actually like, but which captures the sentiment. She has written, and as I said, a lot of articles and books, but 2, Refugee Roulette, which talked about disparities in the asylum adjudication system in the United States, and Lives in the Balance, which is addressing asylum adjudication by the Department of Homeland Security. Both of those books have been impactful in a particularly important place. She has presented, along with her co-authors, in the presence of people who are making those decisions. So she's not just talking to academics. She's not just talking to students. She's not just talking to those of us who are naturally interested in these topics, but she's talking to the people who have the opportunity to change what they do in the future. So that's a wonderful contribution to moving the needle forward in ways that change lives. And so I want to say that that's something that about which I am very proud. She is a senior research associate at the University of London School for Advanced Studies. She has national associations, American Society of International Law, Mid-Atlantic Immigration Professors. She's an avid blogger, including an International Girl Law blog, which you should check out. I didn't know this. In addition to English, she speaks 3 languages, French, Spanish, and Dutch. If I had known that, I had forgotten it. But the last thing I want to say is this. We recruited Professor Ramji Nogales from Georgetown in D.C. And as far as I remember, this wasn't before that your home. And she and her husband have come here and made Philadelphia and this community their home. She is a member of the board of the ACLU, of Esperanza, of the AIDS Law Project. She is contributing both to this institution and to this community. So I'm really pleased to introduce this year's Friel-Scanlan speaker, Professor Jaya Ramji Nogales, who's going to talk about revealing disparities, empirical studies of the asylum process. Thank you.
Thank you very much for the generous introduction, Joanne. And in your usual present way, you've predicted the studies that I'm going to talk to all of you about today. But first, I just want to say what an honor it is to be in the company of such esteemed colleagues accepting this award today. This is particularly sweet because this is an ongoing project that I started in my first year at Temple and has been with me during my entire tenure here. Indeed, I am still working on this project, and I will probably, as one of my co-authors jokes, my co-authors are about 20 years older than I am. He jokes that we'll be working on this until I retire, right? So there's plenty of work to be done. So that leads me to a lot of thank yous. First of all, these empirical projects, as those of you who have undertaken them know, consume a tremendous number of resources. And I've had consistent, generous support from Dean Epps and from former Dean Reinstein from the Clifford Scott Green Fund, so I'm very grateful for that support. I've also had wonderful research deans. The current dean, Greg Mandel, and the former dean, Jane Barron, have supported these studies in a variety of ways. Tremendously generous colleagues. In particular, I want to shout out to Dave Hoffman, our empirical guru, who's been really formative in my development as a scholar and just incredibly generous with his time in helping me on this and other work. Peter Spiro and Jeff Donoff, neither of whom could be here today, but have been very formative as well. And to all the members of the faculty who have heard this story before, probably in faculty colloquia, so I apologize in advance for those of you who are hearing this story another time, but unfortunately I'm going to keep telling this story until the system actually improves, so you're going to be hearing this for many more years. I also wanted to thank the IT folks, to Sham and Nam and all the others. Empirical projects also require a lot of complicated statistical software, and they are constantly installing and updating and finding whatever software I need. I really couldn't have done this without them. My assistant, Josette, who's done things ranging from stuffing envelopes, sending surveys to immigration judges, to arranging travel. And finally, Debbie Feldman and Dorothy Lee, who organized this event, and, you know, frankly, just for putting up with me, thank you to both of them. So it really takes a village to get this work done, and I'm incredibly grateful for the village that I have here to support this research. And also a particular thank you to my husband, Luis. As the saying goes, behind every great woman, there's a great man. He is the great man. Statistical work is terrifying and stress-inducing, and so he often pulls me down off the ceiling when I'm particularly freaked out that I'm not going to find anything or I've gotten everything wrong. And not only does he help calm me down, but he actually gives me solid statistical methodology advice that my colleagues and I have greatly benefited from. So thank you for all your support. So I mentioned that some of you have seen some of these studies before, but today's talk is a bit different. I see this as an opportunity to step back and reflect on some of the implications of my empirical work. My co-authors and I have largely been concerned with demonstrating what's happening on the ground, revealing disparities, as the title of the talk suggests, and then making policy proposals to improve the asylum system. I'm going to spend much of today's discussion highlighting that work, but I also actually want to take a page out of Professor Green's 2013 Friel-Scanlan talk and think about our work as the production of knowledge, so a bit of a spin, not exactly what you were talking about, but a bit of a play on what you were talking about. So both in the classroom, I spend most of my time teaching students about process and about fairness. I hope to inspire them to always stand for procedural fairness in any system that they practice in. But also to think about the fact that it's those of us in this room who are setting the standards by which fairness is measured. Also, as a scholar, I spend a lot of my time revealing disparities and systemic problems in the asylum process. So I want to think about what it is that as scholars we're contributing to public understandings of fairness in our immigration system by describing these problems. And I want to think about what my role should be as a scholar and your roles as lawyers and law students in revealing flaws in the system, in characterizing this as a flawed system, in changing public understanding and public knowledge around the immigration adjudication process. So this question really came to life for me this summer during the Central American migration crisis, when we had all these women and children at our southern border trying to come into the US. Much of the debate that happened this summer was over the question of whether these folks are refugees or not. If our system decided that they were, these women and children could remain in the US. If our system decided they were not, it was deemed appropriate to return 8-year-old kids and their 20-something-year-old moms to countries that can only be described as extraordinarily violent and dangerous, right? San Pedro Sula, the capital of Honduras, is the murder capital of the world, and kids in particular are being targeted there, but if they're not a refugee, it's okay to send them back, right? So less attention was being paid this summer to whether those decisions were being made well, right? I'm going to leave to one side today the substantive question, about the definition of a refugee. I'm taking that on in a current project, don't worry. You guys will get to hear about that soon. But what I really want to focus on today is whether the process that determines whether someone is a refugee or not is a fair one. Is it making accurate decisions? My studies imply that it's not. Perhaps that's not news to lawyers, right, who practice in the system, and not news to most that our immigration system more generally is broken, but I think this is an important message. I think it's important knowledge to be produced and shared with the general public about the problems with the immigration adjudication process. And interestingly, this summer, it was really the lawyers who took the lead in bringing to light in the public imagination the deep problems with the system being used to process Central American migrants. In the age of social media, we're all producers of public knowledge, right? These lawyers sent out video postcards with interviews of lawyers. They posted a comprehensive report on the web last fall. They were blogging. They were getting information out there as best they could. So lawyers are producers of knowledge. Law students are producers of knowledge. What knowledge will you choose to produce in practice, and how will it impact our justice system? So before I get ahead of myself, let me step back and introduce the scholarship that led to this award. So I'm going to describe today both of the two books that Joanne talked about in her introduction. It normally takes at least an hour to describe each book. So I thought I'd just talk for 2 hours today. You guys don't have anywhere to go. It's April Fool's Day. I couldn't resist. It's too bad I don't see Dorothy. I was hoping to give her a little bit of a heart attack. So seriously, so I'm whittling down both of those projects to a talk that's 40 minutes in total. I'm not going to get deep into the weeds on any methodological questions. I imagine most of you in the crowd are not statisticians. I'm happy to answer questions about our approach. And this is just a very abbreviated description of these studies, just a flavor of the kinds of findings. There's a lot more in the books. So let me start, for those of you who aren't familiar with it, with a brief description of the asylum standard and the asylum process. So this is what we're using, coming from the 1951 convention relating to the status of refugees, the UN convention, to determine whether or not someone is a refugee. It's a forward-looking standard. Do they have a fear in the future of persecution? A term that's somewhat contested, but generally means a pretty serious level of mistreatment on account of their membership in one of these groups: race, religion, nationality, political opinion. Those definitions are all relatively clear. Or membership in a social group, particular social group, which is the final catch-all group used to expand the definition of what is a refugee by design. The treaty drafters designed it that way. So that's what these adjudicators are determining. How does the asylum process work? So this is the affirmative asylum process, which is what happens when someone comes forward before being apprehended by immigration authorities and says, I want to apply for asylum. The first step of this process is the Asylum Office. That's a non-adversarial interview. The Asylum Office is part of the Department of Homeland Security, and these are adjudicators who hear pretty much asylum or asylum-related claims only. This is what is known as the first bite at the apple, right? And there are currently 8 regional asylum offices around the country. The numbers of adjudicators are somewhat in flux. So if you lose at the asylum office, then you get a second bite of the apple at immigration court. Your case is determined de novo in immigration court. This is an adversarial process. There are lawyers representing the government who work for Immigration and Customs Enforcement. The judge comes from the Department of Justice. The applicant does not get a paid attorney. There are currently over 260 judges in 58 immigration courts across the country. And then your next administrative appeal is to the Board of Immigration Appeals. This is part of the Department of Justice. It's a review body currently consisting of 14 members. They're appointed by and serving at the pleasure of the Attorney General. They set nationwide precedents for asylum officers and immigration judges to follow. And then, of course, you can appeal to our U.S. federal court system, to the courts of appeals. You can also, after that, appeal to the U.S. Supreme Court. There have been a handful of appeals that have been granted cert in my lifetime, so it's not really a viable appeals option. So I'm not going to start back in my first year on the Temple faculty, the first installment of this project, which is Refugee Roulette, first published in May 2007. This was the first empirical study of decision-making at all 4 levels of the asylum process. The genesis of this book was that my co-authors and I were troubled by anecdotal reports from immigration lawyers suggesting that in asylum cases, some adjudicators were consistently generous, while others were so reluctant to grant asylum to almost any applicant that an asylum seeker might as well give up if their case was assigned to that person. We decided to see if we could get our hands on some very large databases of decisions from all 4 levels of the process to see whether the numbers bore out this hunch that the assignment of the adjudicator may have more impact on asylum outcomes than the merits of the asylum claim. We started by trying to describe this process and became deeply engaged in the question of why this is happening, right? So that's the story I want to tell today. We became deeply concerned about the predictability and accuracy of the process and about severe decisional disparities. So let me start with the asylum offices. I'm just going to give you a flavor graphically of the disparities that we uncovered in our original study. We started by looking at disparities in grant rates within different asylum offices. So we looked at asylum seekers from what we call strong claim countries. That means they had relatively high grant rates over the time frame of the study, and there were a high volume of applicants. So if we look at these 2 asylum offices, we might think that grant rates would be similar within an office. These cases are assigned randomly within an office, and we see that in Region A on the left, right? You can see that slope is relatively flatter. We see grant rates ranging from around 20% to almost 60%. But we were interested to see that Region H on the right has a much steeper slope. This demonstrates inconsistent decision-making. There's a range from around 5% to nearly 80%. It starts a lot lower, it goes a lot higher, the slope is steeper. We can look at this from a different angle if we compare the deviations within each office from that office's mean. So if we look at Region A, right, only 2 of our officers, 2 of 31 officers deviate from the mean by more than 50%. But in Region H, wow, that's a really different story. More than half of the officers, 27 of 53 officers, deviate by more than 50%. Now, if we take a look at what's happening in all 8 regional asylum offices, we see big differences, right? So even where grant rates, overall mean grant rates are similar, we see big variations in whether or not the asylum officers are consistent with the other officers in their office. So in some offices, as few as 2% of the officers deviate from the mean by over 50%. In others, as many as 51% of the officers deviate by over 50%. The same holds if we look at asylum seekers from just one country. I'm not going to subject you to that set of slides, but we tested this out by looking at China, and we found enormous disparities. So this is where the research project started, taking a look at serious disparities in asylum decision-making within offices. Next, I'm going to take you guys to look at the next level of process, the immigration courts. Again, looking at cases involving countries with a high rate of successful asylum seekers. But here, we look at variation across the courts. And again, we find a lot of it. So you're assigned to immigration court according to where you live when you apply for asylum. So not 100% random, but it's fairly random. If you're unlucky enough to migrate to Atlanta or Detroit, those are marked in red, right? Atlanta, you face a 12% grant rate. Detroit, you face a 19% grant rate. If you're lucky enough to have friends or family in New York or San Francisco, because that's the largest reasons why refugees land where they land, those are in the green, you have a 52 or a 54% grant rate, right? These are really big differences for applicants from the same set of countries. Like the asylum offices, when we looked at disparities within courts, we found some courts where disparities seemed reasonable, but others not so reasonable. So I'm going to give you just one unreasonable example. There are plenty more examples in the book. If we take a look at Colombian cases decided in the Miami Immigration Court, Over the 4-year time frame studied, there's a range of a grant rate of 5% all the way up to 88%. And if we look at this comparing deviations from the court mean, we see that 11 of the 22 judges, or 50%, deviated over 50% from the mean. So we were, of course, interested in just describing these disparities that many immigration lawyers have suspected for many years. But we also wanted to understand what might explain these great variations among immigration judges who hear large numbers of similar cases from the same countries in the same courthouse during the same period of time. For immigration judges, we had some biographical information and also some additional data about the cases so we could investigate a little more deeply the relationship between grant rates and factors not related to the merits. So what were our findings? So first of all, I want to take a look at the characteristics of the asylum cases themselves. So what we found with regards to representation, this was not a surprise, it just confirms what other studies have shown. Represented applicants win at a much higher rate, right? Almost 3 times that of the unrepresented applicants. On the right there, that blue bar is from the Georgetown Clinic, where I used to teach. They won cases in the same time frame at a rate of 89%. Now, much as my students were fantastic, I'll be the first one to say this is not because of their skill, right? This was the first case any of them had ever brought to court. And it wasn't because of the selection process. I and my co-authors selected those cases. We largely took them because the calendaring worked for the semester, right? So it was largely about schedule. Our bar was frivolity, right? If a case was frivolous, we wouldn't take it. Otherwise, we would. And I have to confess that my co-author, Phil, and I took particular delight in taking on the hard cases because we thought those made good cases for students to work on. So if anything, right, this is not represented the other way. It's showing the harder cases. So we expected representation would make a difference, but the next finding was pretty surprising. The merits of your asylum case are in principle unrelated to whether you have a dependent spouse or child with you in the US, but your chance of winning goes up by 14% if you have a dependent. That's obviously, I'm talking about a rate differential, not if you subtract 42 from 48, so that's not 14. I know something about math. So this is about the relative difference, not about the absolute difference between the grant rates. All right, so those are the characteristics of the applicants. Let's now take a look at the characteristics of the judges. Perhaps the most interesting and widely reported result of our study is that the gender of the judge made a huge difference. Female immigration judges had a grant rate 44% higher than that of the male judges. This is really interesting, and I'll touch on it again in a few minutes. The other interesting finding was about prior work experience. So what type of work these judges did before they joined the immigration bench, right? So the orange grant rate is if they have that kind of experience. The green grant rate is if they don't have that kind of experience. You can see that folks who worked for the government before joining the bench were less likely to grant. Military were slightly less likely to grant. If you worked for an NGO or in academia, you were more likely to grant. And if you worked in private practice, probably representing immigrants in immigration court, you were also slightly more likely to grant. Even more interesting, prior service with the Department of Homeland Security, the Immigration and Naturalization Service, had a particular impact on grant rate. Every 5-year period of service resulted in a linear downward progression in terms of their grant rate. So there's something about the culture of these offices coming into play in the way they're thinking about these asylum claims. So there are all kinds of factors unrelated to the merits that are coming into play here. And we were just super curious about these questions. The applicant's dependence, the judge's gender and work experience, how and why are they impacting asylum claims? I'll get to more of that in a minute. First, let me talk quickly about the Board of Immigration Appeals. So our major finding with respect to the Board of Immigration Appeals is that this administrative review body does not keep statistics on decision-making by individual members. So that's an important recommendation, right? It's really hard to produce knowledge if you don't have any data. And if you want to have an administrative agency that works well, I can understand that the government doesn't have enough money to pay someone to look at all the data that they're collecting. But if they at least collect the data, right, they might find some academics who are interested in studying it and who can give them feedback about how the process is working. Without that, there's not a lot we could do. We were still able to uncover some interesting information without these individualized data, but in the interest of time, I'm going to skip through those BIA findings, and I have to say, for the record, we are still trying to get them to track these data. I had a conversation with some folks at the Executive Office of Immigration Review just a couple weeks ago, and we're like, you keeping it yet? No, still not keeping it. So I'll be up here telling this story until they start keeping data. Then let's take a look at our federal court system. So again, we found some really intriguing results, some relationships between non-merits factors and outcomes. I'm just going to give you two examples. In the first example, we studied our very own Third Circuit and the Sixth Circuit, where overall rates of decisions in favor of asylum seekers were very similar. So if we look in the Third Circuit at votes to remand in asylum cases, right, these are votes in favor of the asylum seeker because the government can't appeal to the federal courts of appeals. The disparities are pretty small. Only 1 of 16 judges deviates by more than 50%. And when we break down the votes by political party of appointing president, right, the red triangles for Republicans, the blue diamonds, lucky stars for Democratic appointees, we see very little difference. Like, right, they're really tracking each other. It's hard to tell who's who. But the picture is really different in the Sixth Circuit. 8 of 13 judges deviate from the circuit mean by over 50%. And here, we see a serious divergence in the rates, in the votes of Republican and Democratic appointees. These are some really interesting dynamics. So I couldn't resist. We're in the Third Circuit, I asked a Third Circuit judge off the record about what was happening. And the answer was really interesting. The answer was, all the judges on the Third Circuit are friends, regardless of our political perspectives. We have lunch together. We talk about cases. We learn from each other's perspectives. So it sounded to me like that's the kind of bench we want, right? Both in federal court and in the immigration process. It's these kinds of interactions between people from different perspectives talking about what's happening in their cases that are likely to produce the most thoughtful and, I would argue, probably the most accurate decisions. So I thought that was an important takeaway from this study. So when we look at what's going on in all the circuits, right, we again see some really interesting disparities. We're supposed to have one national immigration law, but look at these remand rates by circuit. The Seventh Circuit's remand rate is 36%. Most circuits have remand rates of about 15 to 20%, but the 3 southern circuits, covering the swath of states from Texas through Maryland, have remand rates of less than 5%. Right? So the Seventh Circuit is what I would attribute that to what we could call the Judge Posner effect. Judge Posner, not a bleeding heart liberal, is completely appalled by what's happening in the immigration process and repeatedly smacks down, right, the Board of Immigration Appeal, the immigration judges for some of the decisions that are coming through. He was actually, I was not there, but my co-authors presented this study in Chicago, and he was there and he saw this slide, and he was very surprised to see that difference. But I think that's largely coming from him. But what's up with these other regional differences, right? I don't know, but it's pretty interesting. This curiosity about what was driving the differences pushed us to undertake an in-depth study of the asylum offices only. This is our more recent book that came out last year, Lives in the Balance. This enabled us to focus really deeply on this level of the process. So in addition to quantitative work, we did a lot of qualitative work this time. We got lots more biographical information about these asylum officers than we'd had about the immigration judges. The Department of Homeland Security conducted a survey of asylum officers. We interviewed the supervisory asylum officers at least one from each asylum office, and perhaps most importantly, as Joanne mentioned, I didn't present at all 8 asylum offices because I had a baby while we were writing this book, but my co-authors, I presented this draft book at all 8 asylum offices. So we not only took questions from the asylum officers, but we put up our most interesting findings and said, what's going on here? We have no idea. What does this pattern mean? Why is this happening? And we got some really terrific answers from them that really helped us to better understand the system. So we're starting to really tease out what's happening in the system. We're starting to get really good explanations. We're starting to produce knowledge that might help us and help the Department of Homeland Security to better understand and reform the system. So let me start with the disparities that we saw between the regional asylum offices. There were some serious differences overall. Again, I'm just giving you a couple of slices of the data. So first of all, for Somalis, we saw a grant rate of 34% in Chicago and 89% in San Francisco. This is a bit curious. I mean, 89%, that's pretty high, but Somalia is a country where there are pretty serious human rights violations, right? So the fact that 66% of the applicants in Chicago are not being granted asylum coming from Somalia, that's a bit surprising. So we have this East Coast, West Coast thing going on, not just Tupac and Biggie Smalls, right? So the grant rate on the West Coast seemed much higher than corresponding rates on the East Coast. So I'm from the West Coast. My first reaction was, people are just happier out there, right? I'm not sure that that's true. So for Indonesians, we see the grant rate in Newark was 20%. The grant rate in San Francisco was 54%. For Russians, it was 28% in New York and 65% in San Francisco. And also what we heard in San Francisco, of course, our question to these folks in San Francisco was like, why are your grant rates so much higher than everyone else's? And they said, and obviously there are lots of free legal services in San Francisco, but that's also true of New York. And they said the real difference is there's support for asylum applicants beyond legal services. There are mental health services. There are medical services. There are places where they can learn English, right? There are places where they can go get places that will help them get jobs. So they said that there's just a lot of support overall, and that makes a big difference. All right, so this next slide shows us, we're going to move now into disparities within asylum office. We see that some offices still have very high internal rates of disparity despite our efforts to educate them with refugee roulette. So in Newark, we now know, well, we always kind of knew Region H in the last study is Newark. We always kind of knew, but they just now gave us permission to tell everyone. So in Newark, the grant rates over the time frame studied ranged from 2.5% to 92.5%. There was somewhat less disparity when we looked at only the most recent 3-year period of the study, which was the time frame after we brought our refugee roulette study to the attention of the government, but still the grant rates range from about 10% to about 55%. So we're producing knowledge. I'm not sure anyone's listening, but we are producing knowledge about the system. This next slide is what we call a box plot. This is comparing variations among individual officers within all 8 regions. The black line in the middle of each box is the median grant rate for the region. The red box shows the range of rates for the middle 50% of officers within the region, and the black line sticking out on the ends show the full range of rates for officers from the region, except for those extreme outliers, which you see represented by circles. So this box plot shows the time frame from July 2006 to June 2009. Don't worry about Houston. They didn't have, that's the top box. They didn't have enough cases to make that outcome reliable. But you can see the second and third, Arlington and New York, there's not too much disparity there, but you can see there's a great deal of disparity if you look at the second and third from the bottom, Miami and Los Angeles, both as to the entire group of officers and the middle 50%. So we're seeing, again, really different ranges of disparities. So again, why is this happening? We started to get into more of an explanation with this book. So first of all, we looked at grant rates over time, right? We had a pretty long time frame here, and we could start to tell an interesting story about law, policy, and politics and their impact on decision making. So we broke our data down. Our data runs from October 1st, 1995 to June 8th, 2009. We broke it down into 4 eras, so we could look at the impact of major world events and legal and policy changes. So we started our start date October 1995, and then we broke off that first chunk on June 16th, 1998, which was the effective date of the 1-year filing deadline, which is basically what it sounds like. It's a new law that came into effect that said asylum applicants have to file for asylum within 1 year of entering the U.S. Then the next breaking point, the end of that second and beginning of the third, are the terrorist attacks of September 11th, 2001. And then finally, that next break that you see there, June 30th, 2006, is the effective implementation date of the Real ID Act, which is, again, a federal statute that changed the credibility requirements for asylum claims. A lot of advocates were worried about this. So we see, first of all, a dramatic rise in grant rates, right, between the first and second era. We think this is because of a 1995 procedural reform by the Department of Homeland Security, which delinked the right to work from the filing of an asylum claim, right? Now asylum applicants are only allowed to work after they're granted asylum or after there's been a lengthy delay by the government. Before 1995, folks could just file asylum, even if they had weak cases, and get work authorization immediately. So what we saw after that change is a huge drop in the overall number of applications and an increase in grant rates. We think the overall quality increased as a result of this change. Then we see this drop off after September 11th from 56% to 46%. We think there are 3 potential reasons for this. So first of all, just the general sense of national insecurity after the terrorist attacks. Second of all, changes in INS policy. So you may remember that a few months after the attacks, the INS sent a visa renewal to Mohammed Atta, who died attacking the World Trade Center. There was a huge uproar, a huge public uproar, a huge uproar in Congress, and the 4 top international affairs officials of INS were fired in what's known now internally as the massacre, right? So that is definitely still talked about today. Around the same time, the acting head of the Department of Homeland Security, James Ziegler, sent around what's known as a zero tolerance memo, and I'll quote from that memo. Effective immediately, I am implementing a zero tolerance policy with regards to INS employees who fail to abide by headquarters issued policy and field instructions. I would like to make it clear that disregarding field guidance or other INS policy will not be tolerated. The days of looking the other way are over. Individuals who fail to abide by issued field guidance or other INS policy will be disciplined appropriately. We understand that some officers may have interpreted this memo to mean that it was a lot riskier to grant asylum, right, than to send the cases up to the immigration court for them and let them decide it. Finally, this is also when asylum officers started getting a lot more information on applicants from much more rigorous security checks, and when fraud officers were being sent into the field. So there's just a lot more information about the applicants. This is what the officers told us. And finally, we can see from that end result that Real ID, which changed the credibility standards, actually had much less impact on outcomes than advocates had feared. All right, so this is another story of legal and policy changes relating to gender. In 1996 and 1997 fiscal years, men and women won asylum about the same rate, but in almost every year since fiscal 97, women won asylum at a higher rate than men. The rate was on average 12% higher. So we think this is due to 2 changes in the mid-1990s. In 1995, INS issued non-binding gender guidelines, alerting asylum officers to the kinds of persecution women face around the world and providing guidance on how to interview women about sexual assaults. We also saw around the same time 2 highly publicized cases calling attention, right, producing knowledge, changing public perceptions about the plight of persecuted women. First of all, the Kasinga case, which dealt with female genital mutilation, and second of all, the RA case, which Professor Mandel worked on, dealing with domestic violence. So this alerted many people, including asylum officers, to the concept of domestic violence, female genital mutilation as a human rights issue as a basis for asylum. So those are some policy impacts, some external factors. We also managed to dig deeper into individual characteristics of applicants and officers to unravel some of these mysteries we found in refugee roulette. So similarly, to the refugee roulette findings, we found that applicants with dependents were granted asylum more often. But this time we could ask the officers, what's going on? Why are these folks with dependents being granted asylum more often? That shouldn't have an impact on their asylum claim. So we got some really interesting answers, right? So one set of answers related to sympathy to the applicants. So what one of the officers told us is that you have to what's called ID dependents. So dependents have to come into the office with the principal applicant, and the asylum officer has to check to make sure they are who they say they are. And they said, look, you got 2 cute kids there. It's really much harder to send this person back to where they came from, right? So there's the human angle there. They also said, right, someone just looks more responsible when they have a spouse and kids with them than they do when they're single. So they also said family members can corroborate the story, right? If the principal applicant is there with their spouse and kids, they might be able to provide, they might be live witnesses who can talk about the story. And they also thought it may be that folks with dependents spent more time on their claims because they have more at stake, right? They're thinking about protecting their children, so they spend more time preparing their claims. Another possible explanation is that the asylum officers have less time to interview these folks. So you have to run security and background checks on every member of the family. That comes out of the 4 hours that you have for your asylum interview. So maybe some combination of these factors are coming into play. Sympathy to the applicants, not much time to make decisions, right? These decisions are being made more on a gut basis than the others. So we dug a little deeper into what's happening with the dependents, and we saw this factor of having dependents made a real difference for folks from Central America and folks from China, a lot less difference for people coming from Europe and Central Asia. So we can't entirely eliminate the human sympathy factor from the process, but how can we make the process fairer for those who may be less sympathetic? So one thing we found, digging into the data a little deeper, was that representation made a much bigger difference to those without dependents. So the folks with dependents on the left, pro se is orange, represented as green, you can see very little difference. But on the right, those with no dependents, it made a big difference whether they were represented or not. The asylum officers told us this helped to make them look more credible. They told us specifically single men who entered without inspection, right, who came across the border without having their documents checked, they're the most suspicious category, right? We suspect that their claims are weak or fraudulent, but if they have a representative, right, that helps us to find them more credible. So finally, we looked at the characteristics of the officers. So I'm going to start with the gender of the judge question from Refugee Roulette. We repeated that study with the data on asylum decisions by asylum officers. And what we found was that for asylum officers, the grant rate for men and women was virtually identical. So what explains that difference between immigration judges and asylum officers? We don't know which factors contributed to the significant difference, but we have a couple of hypotheses. One is that in the aggregate, immigration judges assume their jobs later in their careers, right? Asylum office is a, fresh out of law school, a few years out of law school kind of job. Immigration judges later in the career. And many more male than female immigration judges had served law enforcement roles before going on the bench. By contrast, the asylum officer job, people take that early in their careers before adopting the culture of another agency. But this, of course, can't be the only explanation. The regression analysis controlled for prior work experience, and we still see this robust gender differential. So I think the stronger explanation is that training and supervision make a huge difference. Asylum officers receive very substantial initial training and ongoing training, usually for at least half a day every week. Indeed, we presented our findings, the findings of the study at some of those trainings, and they focus on only asylum cases. In contrast, immigration judges who hear all kinds of immigration cases have no training at all, no training to start, no requirement of knowing anything at all about immigration law before they join the bench, and their training budget has been cut entirely, right? So this may lead to these kinds of differences, right? So asylum officers' work backgrounds didn't make a big difference, but we were able to look at their educational backgrounds, information we didn't have for refugee roulette. The question we were able to look at is whether it mattered if they were lawyers, because the largest group of educational background was lawyers, and so we could think about that. So this slide shows that for applicants with representatives, right, so that's the folks on the right there, it did not matter so much whether the asylum officer had a law degree. But for those without representatives, the pro se folks on the left, the officers with the JD degree, the green bar there, granted asylum at a rate 24% higher than officers without such degrees. Why could that be? What's happening here? So again, we asked this question of some of the folks in the field, and they said maybe what's happening is that for pro se applicants, officers with law degrees let their legal training take over, right? And in effect, in some ways become advocates for the applicants. They probe the facts, they think about theories that might help the applicants. By contrast, when the applicant is represented, the officer assumes a more judge-like role and lets the representative do the advocacy. And when a non-lawyer interviews a pro se applicant, nobody's probing, nobody's pressing, right? And the grant rate goes down. We also, though, managed to break this data down a little further. So whether an officer had a JD or not appeared to make virtually no difference when the applicants, so this is on the left side, when the applicants came from a country whose human rights conditions were deemed highly abusive, using this political freedom standard index, a political science index. But it made a difference when applicants came from countries with human rights conditions that were classified as less abusive. So fewer of these classical human rights, political and civil rights violations. In those cases, so those on the left of that left-hand graph, the JDs granted asylum at a rate of 50% and non-JDs granted asylum at a rate of 42%. Here, what the officers told us is maybe when the human rights abuses are more obvious, the postgraduate training of the officer doesn't really matter, right? Because the asylum claim is clear-cut. But when an applicant comes from a country with a more mixed human rights records, the claims may be less classic. These may be these membership in a particular social group claims. And the lawyers might be more likely to see how they fit into the framework of the Refugee Act. One of the officers we interviewed told us that lawyers are not only better at fitting claims into legal frameworks, so in doing the work that asylum officers need to be doing, but they're also much more confident in pushing forward non-traditional claims. Maybe they took an immigration class or a refugee law class in law school. Maybe they represented asylum seekers in practice or in law school, and they're just more comfortable knowing that this is a valid asylum claim. So on the right, we can see that the difference between JD and non-JD adjudicators is particularly striking with respect to Latin American applicants. The JDs granted asylum at a rate 68% higher than the non-JDs to these applicants. And again, this tells the same story, right? These may be non-traditional claims. From Latin America, we see claims about gang violence, we see claims of domestic violence, and lawyers may be better, right, at picking these out and deciding that these are valid asylum claims, at producing information within the system. So that concludes the graphical part of this presentation, but takes me back to the theme about producing knowledge about the system. We now have a lot of information, qualitative and quantitative, about the asylum process. We know not only about serious disparities in grant rates, but we have some understanding of factors that might be driving disparities. What does this exploration reveal about the system? We could tell a darker story and we could tell a sunnier story. The darker story is that we just can't trust the accuracy of decisions produced by such a flawed process. Not only lawyers, but the American public and immigrants should be deeply skeptical of decisions coming out of the immigration adjudication process. Once we lose faith in the system in this way, we really condemn the system. Institutions of justice obtain their legitimacy from perceptions of fairness. If they're roundly perceived as unfair, people will be unwilling to abide by their rulings. The executive is simply not capable of enforcing all the laws on the books in this country. These laws depend on perceptions of legitimacy for people to respect these judgments and self-enforce. And when these judgments are respected, people won't comply with them, which sounds actually a whole lot like our immigration system, right? So the sunnier story is that by making this knowledge about the system public, we're contributing to efforts to improve the system. What the immigration adjudication system needs most desperately are more resources. There's very little public appetite to spend money on the immigration adjudication process. One of the recent comprehensive immigration reform bills that was put before Congress had a line item for night vision goggles for Border Patrol, but no money for the immigration adjudication process, right? So it's about public appetite for spending money. If by producing knowledge we can start to change public opinion, that's an enormously important step towards improving systems of justice. If the public thinks it's important to spend money on the immigration adjudication system, their representatives in Congress might someday start to think the same thing. So beyond changing public understanding of the system, this deep knowledge about the system produces new ideas about how it could be reformed to minimize these disparities. And this is an essential part of our roles as scholars, as lawyers, as law students, producing knowledge about systems of justice with the aim of producing fairness for every person who enters the system. And I just want to end with a final thank you to all of you for your support in my efforts to play a small role in improving the fairness of our asylum adjudication system.